Thanks, everyone. It's such a delight to be here. And today I've been asked to talk about Australia's trade policy approach and whether it serves our nation's interests. And this topic really reflects my expertise as a political scientist. So unlike many in the room, I'm neither a legal scholar nor necessarily an IP specialist, but my research over the past decade has certainly canvassed the political and economic consequences of particular approaches to trade and IP policy. So I hope that my comments are helpful in providing, I guess, some big picture context and some food for thought as we work through what is really a fascinating program of papers. So a few years ago, you could really have been forgiven for expecting a bit of a quiet life as a political scientist interested in international trade. Wars were really things that our more interesting international relations colleagues spent time examining, while us international political economists focused on the apparently less dramatic low politics of international economic agreements. But how times change. Here we are in 2019 staring down a trade war between two major global powers. So today I wanted to reflect on Australia's trade policy approach in light of this striking development and a number of other recent developments. And America's recent actions, I think it's fair to say, have sparked quite grave concerns about the future of what we call the rules-based international trading order. And indeed, defending the rules-based international order has emerged as a key theme for the federal government, for the Commonwealth government, in its foreign policy white paper, which was released in 2017. And so in light of these challenges, it's really important, it's an important time, I think, for us to reflect on our existing trade policy approach, to ask whether we're on track as a nation, if our existing approach to international trade agreements is serving us well, and will help, most importantly, help us to achieve our foreign policy and indeed our domestic economic objectives. So it's those kinds of questions that I want to address today. Let me start with just a few words about the rules-based international order and where it's at. Since the end of World War II, obviously the United States has been the primary proponent and key defender of a rules-based international trading order. So America's recent embrace of unilateralism and protectionism has caused very deep anxiety in Australia about the disintegration of this order and sparked fears about a global protectionist turn. And that kind of situation would, of course, be devastating for this country given our level of trade dependence. But while these anxieties are really understandable, I'd like to start by just highlighting what I see as the underlying resilience of the rules-based trading order. And for evidence of that resilience, we really only need to look at the collective response to America's withdrawal from the Trans-Pacific Partnership, the 12-country agreement in 2017, which prior to President Trump, America had been vigorously pushing. Now, that was a really stunning development at the time, but what was equally stunning was the response of the remaining 11 parties to America's withdrawal. Because while analysts around the globe, including myself, were predicting the end of the TPP, at least in the short term, the remaining parties were defying the odds and forging ahead with a new deal. And thanks largely to Australia's leadership on that issue, these 11 nations were able to secure a revised deal, the TPP-11, in less than a year. And what that tells us, or what it tells me, is that despite America's recent bout of protectionism and unilateralism, appetite for international trade rules in many countries is really very strong. And this appetite has recently been reinforced by the launch of the Australia-EU trade negotiations, which of course followed the conclusion of the Australia-Indonesia bilateral partnership. So, viewed in this light, I think it's fair to say that there's currently more rule-making going on than rule-breaking. And Australia is playing a very important role in that rule-making through its aggressive pursuit of preferential trade agreements, PTAs. So people like me spend so much time, and like you guys, I'm sure, spend so much time examining PTAs, preferential trade agreements, because since the stalling of the WTO in early 2000, PTAs have become the primary site of international rulemaking in trade and investment. And in this sense, what was once a kind of international norm of multilateralism has given way to a norm of preferentialism, of doing deals with just a small number of people. And in its 2017 Foreign Policy White Paper, the Australian government identified PTAs, identified preferential trade agreements, as a key tool for advancing its foreign policy objectives, from defending the rules-based order against protectionism, especially on the part of the USA, to ensuring that emerging economies like China abide by liberal economic principles. So given its emphasis on PTAs, a key question for the Commonwealth Government has to be, well, how well do the trade rules that we are promoting, that we're advocating, that we're embracing, actually help us to advance our foreign policy objectives and indeed our domestic economic objectives? And this is the focus of a larger study that I've been working on in recent times in dialogue with DFAT and the Attorney General's Department. And so I start that study by identifying the government's key trade-related foreign policy objectives. And the white paper lists 4 foreign policy objectives that relate to trade or that can be advanced through trade. I'm not going to read them out. And then to evaluate Australia's contribution to the international rulemaking, I ask, well, how well do the trade rules that we're promoting and advancing actually help to secure these objectives? And I pay particular attention to identifying the potential risks associated with our current approach to trade rulemaking. And the main thrust of my findings is that there's actually a significant degree of conflict between our stated goals on the one hand and our trade policy approach on the other. That is, many of the trade and investment rules that we are promoting and supporting actually conflict with or risk undermining our foreign policy objectives. Now, that's not to say that there's nothing positive at all in our approach to international economic policy. But in the spirit of progress, in the spirit of identifying the risks and dealing with them, I'm really trying to just focus on highlighting the areas for improvement. So let me just briefly outline my argument in relation just to the first 3 of these goals, and highlighting where relevant the particular role of intellectual property rules and trade. So, in terms of promoting an open, inclusive and prosperous Indo-Pacific region in which the rights of all states are respected. Well, in light of this goal, I think it's important to at least acknowledge the potentially perverse relationship between preferentialism and protectionism. And given that perverse relationship, there's some real risks involved in using PTAs, using preferential deals as a weapon against protectionist practices. There are at least 3 ways in which preferentialism can actually reinforce protectionism and discrimination and market distortion and undermine support for a rules-based international order. First, preferentialism can fuel support for discrimination among powerful business sectors by delivering exclusive benefits that would be undermined by more inclusive agreements. And this is why lots of Australian agricultural producers are now arguing against America's return to the TPP, because that would actually undermine their advantage in the Japanese market. So PTAs can promote beggar thy neighbour attitudes among quite powerful political groups. Second, PTAs can entrench discrimination and market distortion when they include provisions that violate the principles of the WTO-based liberal international order. And Australia is currently promoting a number of PTAs that do precisely this. For example, several of our PTAs, from the Australia-US agreement to the TPP-11, extend intellectual property provisions well beyond limits deemed acceptable by most WTO members. These protections violate liberal principles by entrenching monopolies, thwarting competition, and encouraging a business model based on rent extraction over job-creating productive investment. Similarly, investor-state dispute settlement provisions violate the WTO's foundational principles of national treatment and non-discrimination. They do that by giving foreign firms more rights than local firms, allowing only foreign firms the right to sue national governments for regulatory changes that might impact on their profit-making expectations. Moreover, ISDS provisions directly conflict with the government's stated objective of ensuring that the rights of all states are respected. Specifically, they can transgress the sovereign right and democratic imperative of governments to regulate to secure the economic, social and environmental well-being of their citizens. ISDS provisions can impinge on those rights by subjecting critical regulations related to financial stability, health, environmental and energy security to legal challenge and elimination by foreign firms. So the inclusion of ISDS in the TPP-11 is what made it such a controversial deal for many, leading to quite unprecedented public outcry in many jurisdictions. And this brings me to the third way in which PTAs can undermine support for a rules-based international order, by slowly and steadily supplanting mutually agreed multilateral rules with highly controversial rules that are first secured and then gradually normalised in successive preferential deals. And this risks further fracturing support for international rules, which become viewed by the public as less and less representative of shared interests and more representative of a very narrow but very powerful set of interests seeking to advance rent-extracting or market-distorting objectives. And we're currently witnessing precisely that outcome as public opposition to trade deals that include that kind of WTO plus provisions and ISDS indeed unfold. Now, worryingly, those public objections are often erroneously sheeted home by the Australian government to protectionist sentiment. But that's a really dangerous misdiagnosis, because as I've just mentioned, objections are more often grounded in concerns about the market distorting and rent extracting aspects of trade deals and their impacts on the abilities of states to regulate for legitimate purposes. So the upshot is, if the objective is to foster support for the rules-based economic order, the Australian government should really ensure that the rules that it's promoting support rather than undermine stable and inclusive and sustainable economic growth in our region and beyond. Turning to the second point, to deliver more opportunities for Australian businesses globally. Well, some of Australia's recent PTAs deliver some outstanding new market access opportunities for some Australian firms, especially in some agricultural and service industries. But when it comes to benefits for Australia as a whole, which is certainly the yardstick against which outcomes should be measured by the government, the picture is less rosy. As I've detailed in numerous papers, and it's well available on the public record, modelling of our recent deals from the TPP-11 to the China, Japan and Korea bilaterals show that their overall economic benefit to Australia is likely to be very modest. From the TPP-11, we expect a boost to GDP of about 0.5% by 2030, and moreover, that modelling doesn't include substantial costs likely to arise from other non-tariff related provisions of the deal, including intellectual property and potentially investor-state dispute settlement. And those really modest gains shouldn't surprise us, because unlike multilateral deals, PTAs typically produce trade diversion, which is a welfare-reducing outcome, and that was precisely the outcome of the much-touted Australia-US free trade agreement. Now, the key point is, if the government wishes to maintain public support for its PTA agenda, it should be very wary of overselling the likely benefits. Otherwise, the risk is that unmet expectations fuel public scepticism and undermine support for this particular rulemaking enterprise. Now, looking at this market access issue through a slightly different lens, it's also really important to ask, well, where our PTAs do deliver meaningful market access, meaningful new market access, do the Australian firms actually have the support that they need to capitalise on those opportunities? And in this context, Australia's trade policy approach since 2013 has been marked by a really worrying trend. On the one hand, the government's pumped vast resources into negotiating preferential trade agreements that increase market access, which is a good thing, but on the other hand, it's been dismantling policy initiatives that would help boost the innovation and export capacity of Australian firms. And it's also been signing trade deals with IP provisions that arguably throttle innovation and hinder the development and vitality of the digital economy in Australia. So, for example, some recent PTAs have sought to introduce TRIPS plus patent and copyright protections that would delay follow-on innovation and creativity, to extend protections for trade secrets that can limit knowledge spillovers, to enforce technological protection measures in ways that prevent experimentation and innovation, especially in new areas like digital security, that compel governments to lock in worst practice safe harbour regulations that fail to protect digital intermediaries from false accusations of copyright violations, thus constituting a serious deterrent to business in the digital economy. And of course, Professor Rimmer has written extensively on these topics, as has Kimberly Weatherall. So I think it's worth pointing out that worst practice safe harbour regulations can also undermine internet freedom and limit free speech and the free flow of information, which is foundational to advancing democratic and educational objectives. So my point is that as we've been pursuing market access on the one hand, we've been introducing simultaneously regulations that make it harder for firms to prosper in the digital economy, and we'll hear more about firms trying to prosper in the digital economy from Professor Shahid soon. So thanks to those policy inconsistencies and reversals, Australia is now really an outlier among advanced industrial countries in terms of the variety and depth of support that we provide to local firms at every stage of the business cycle. And moreover, the risks to Australian competitiveness posed by this growing disconnect between our trade policy and our industry policy are being amplified by a host of global challenges. Perhaps the most significant is the growing financialisation trend, which is starving many smaller Australian firms of the funds they need to establish or expand new enterprises, especially technology-intensive ones. Under financialisation, private financial institutions effectively abandon investment in the productive economy to chase speculative returns. So in many contexts, especially the United States, financialisation has fueled dramatic deindustrialisation, which poses a major economic and political challenge and is heavily implicated in the rise of populism. Now, in response to financialisation, many developed countries, from the UK to South Korea, have been experimenting with new ways to keep the financial and productive sectors of their economies connected to support innovation and job creation and export expansion. I call these efforts financial activism. But in Australia, early efforts with financial activism, such as the establishment of the Clean Energy Finance Corporation, have been subjected to unsophisticated criticism by some elected officials who bizarrely equate any kind of strategic activism with protectionism. So this growing disconnect between Australian trade and industry policy presents a major risk to the government's quest to deliver more opportunities to Australian firms globally. There's absolutely no question that the Australian government should be concerned about protectionism and defend against it, yes. But in their efforts to do so, policymakers have to learn to distinguish between protectionism proper and strategic industry policies that are fully compliant with our international trade obligations. Until they do this and take serious steps to reconnect our trade policies with our industry policies, Australian firms, digital and otherwise, will continue to be disadvantaged in global markets despite our proactivism on the PTA front. Now, very quickly, turning to this final point of promoting and protecting the international rules that support stability and prosperity. So Australia obviously occupies a region largely populated by developing nations. So nurturing a development-friendly trade regime is crucial to Australia's goal of supporting peace and prosperity in the region. But what do development-friendly international economic rules look like? This is a hugely contentious question, and the answer really just depends on your beliefs about where development comes from and your beliefs about the role of the government in that process. Now, the dominant liberal belief holds that development just springs spontaneously from a country's exposure to international trade and investment flows, combined with the state's embrace of privatisation and liberalisation and deregulation, and its commitment to market-enhancing good governance, rule of law, transparency, and its promotion of human capabilities. These liberal beliefs are now firmly entrenched in the existing framework of international trade rules that promote economic openness on the one hand, and a quintessentially liberal, that is limited, role for the state in national economic governance on the other. But as history shows, and as volumes of detailed empirical research reveals, no country has ever successfully developed by simply embracing trade and investment openness and focusing on good governance. And this is particularly true if we define development in the classical sense to involve the large-scale techno-industrial transformation of the nation and the associated creation of higher wage and higher skilled and higher value-added jobs, rather as the experiences of our most successful regional neighbours, Japan, Korea, Taiwan, now China, show successful development has hinged on the government's strategic management of the nation's integration into the global economy. And this management has been designed to ensure that the gradual exposure to international trade and investment promotes the upgrading of local firms rather than their suppression or displacement by foreign competition. The East Asian Three could pursue such a strategic approach to global economic integration because of an enabling international environment. In particular, international trade rules were far more permissive of development-friendly policies like local content and technology transfer requirements that linked foreign direct investment positively with local development outcomes. Financial markets were more tightly regulated, enabling governments to carefully manage capital inflows and outflows and to intervene in markets to mitigate against financial instability and avert crisis. There was no overwhelming pressure to rapidly privatise state-owned financial institutions, and there was no rule preventing states from creatively combining privatisation and deregulation with re-regulation where necessary to keep finance and production connected. The circumstances facing developing countries now are entirely different. Indeed, the WTO TRIPS agreement sparked a massive increase in foreign direct investment to developing nations as firms in developing countries like the US became confident to offshore more and more of their production, even their advanced manufacturing production, knowing that their intellectual property would be protected. But at the same time as TRIPS was enabling this massive expansion of foreign direct investment, other international trade rules, including the WTO's TRIMS agreement, outlawed the kinds of policies that have historically enabled governments to positively connect that foreign investment with local development. And this particular constraint has proved particularly developmentally detrimental in light of the growing fragmentation and geographical distribution of production and the emergence of global value chains. Under these conditions, foreign firms are now proving far less interested in upgrading the techno-industrial capabilities of the nations in which they invest. And this is perhaps one reason why this explosion of FDI across the developing world over the past 2 decades hasn't produced more positive development spillovers in less developed economies. Indeed, this increase in FDI has coincided with the worrying onset of premature deindustrialisation across the developing world, a trend comprehensively documented by Harvard economist Danny Roderick. So premature deindustrialisation and this shift towards low-wage, low-value-added service industries characterised by high levels of informal employment isn't just economically detrimental for developing countries, it's politically detrimental as well in that it actually makes democratisation less likely and more fragile because political parties associated with democratic movements have tended to come out of a labour movement. So, where does that leave us? Oh my. The point is that by promoting international trade and investment rules that actually constrain the policy space and arguably inhibit the industrialisation of our neighbours, Australia risks failing in its objective to support not only the economic development of the region, but its political development and its political stability as well. So I think that there is a very good case for rethinking our approach to trade policy, for the reason that it is not just in our own benefit, but the benefit of the future development and stability of the region. So I have some proposals there for the key challenges for Australian trade policy makers, but I've probably reached my time, have I? Oh, I haven't. Well, let me just briefly take you through those. So in light of these conflicts, the key challenges for Australia can be summarised as: we have to acknowledge and take steps to mitigate against this potentially perverse relationship between preferentialism and protectionism. We have to ensure that the trade and investment rules that we're promoting don't violate commitments to the principles of national treatment and non-discrimination in the WTO. We have to refrain from overselling the likely benefits of PTAs and creating inflated expectations on behalf of the Australian population. We rely too much on trade policy to do economic reform in this country. It's not the solution to everything, and we should stop relying on it as such. We need to learn to distinguish between protectionism and strategic activism, with a view to having a more sophisticated debate in this country about the state's role in securing international competitiveness. We are a real outlier when it comes to the idea of strategic techno-industrial governance, which is embraced across most advanced countries in the world. We need to take urgent steps to reconnect our trade and industry policy initiatives to bolster the competitiveness of Australian firms and counter the challenge to national prosperity posed by financialisation. We should reject trade and investment rules that don't respect the rights of governments to regulate to secure the social, environmental and economic well-being of their citizens. And finally, we could reject or revise trade and investment rules that impinge on the development space of our neighbours and prevent them from mitigating the serious development challenges posed by the geographical distribution of production, by financialisation and deindustrialisation. I think that's probably enough work for the government to be getting on with, and I hope that that's a helpful framing for discussions today.